Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Good morning, everyone. Happy Thursday. It is Thursday, November 7th. We are gathering today for a Bryan Kohberger hearing. Welcome in. Welcome in. I hope you have your coffee. Good morning, moderators. How are my moderators this morning? Good morning, everybody. Good morning. We are live. We are waiting for the Idaho 4th District Court to begin for Bryan Kohberger. Hello, Miss Potato and Angie B. Feminem just became a lawful listener. Not just a listener, but a lawful one. Thank you, Feminem. Ganja, good morning. Good morning, Hummingbird. I'm seeing you guys talk about your weather. Sounds chilly. It is misting, it's overcast, and it's humid here in Florida. Angie B coming in hot with 30 months. Coming in hot, just like the fajita. Thank you, Ange. Lindsay, good to see you. Missy, always good to see you. We got olive juice in here. So what is happening, guys? We are going to be talking about the death penalty that is on the table. Hey, Betty Smith. Hey, welcome back, bad girl. Welcome back. Welcome back, everybody. Hit that like button if you haven't already. Lisa Rose, good morning. Alina. Who else is here that I missed? Snazzy Trinkets was number 45 on hitting that like button. Uninvited Ghetto Superstar. Sarah with an H. I am J with no E, by the way. Marie Duffy, good morning. Good to see all of you guys. So I missed. You did? Ember Burns got married in this courthouse in 94 to her ex. She's puking. Hello, Christine. Wop, 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 wop. Nash Native, good to see you, sweetheart. Glad you could make it. Mr. Quinn, good to see you as always. Schmicky, good morning. Naomi, good morning. I enjoyed your live coverage on the elections. Thanks, Naomi. Thanks for joining today. We had a lot of fun that night. We sure did, didn't we? I'll tell you what, you know how I told you guys that the videos get dinged every time you play a song for more than 3 seconds? That one had, I shit you not, probably 10 songs. We were having a lot of fun that night. Thank you for being there, Naomi. We gave away cooterships and everything. How does the death penalty violate Kohberger's rights? Exactly. Because they're going to say, I glanced over the paperwork, and they're going to say, we haven't had time to go through it yet, but they're going to say something to the effect that Idaho doesn't have a method to kill him, I think. That's hilarious, Ganja. Lucia, good morning. Good morning. Let's go to, we have a few minutes. It's going to start here in about 9 minutes. But let's take a little peek at the court docs while we wait. So, you know, Bryan Kohberger, he loves his lawyers to file for him. This is all his docket. We're not even, we're to 2024. This is all his 2024 filings. Order of proceedings. Let's take a look at that. I posted that earlier. Oh, Barbara Wolf. She may testify today. Do you guys know who Barbara Wolf is? I forgot to tell you guys this. And you're Canadian? Oh my God, Naomi, that's even better. I love it. Bayou, hey babe. Barbara Wolf testified at the OJ trial. Did you guys know this? Let's see if she's going to test. All right, she may testify today. Barbara Wolf, OJ. I can't find any clips of her, but I know that she testified at the OJ trial. Because look, law offices of Andrew D. Myers put it out too. Emerging expert who helped exonerate OJ joins the Kohberger team. Hey, Blue Moon of Kentucky. Good morning. Do you hear this, Ish? Emerging expert who helped exonerate O.J. Simpson joins Kohberger team. Barbara Wolf. Barbara Wolf. So she's going to be, if necessary, the state is objecting to the testimony of Barbara Wolf. And then they're going to have testimony of Barbara Wolf, of Dr. Wolf, if necessary. Thanks, Uninvited. Good morning, Christine. Then the next motion is the motion of execution. And I think that's where they're going to be like, they don't even have a method. Street clothing at public hearings, is going to be number 1. And then Barbara Wolf is going to be, woo, werewolves in London. She's going to be after that. And then method of execution. And then the state is objecting to the testimony of Professor Cover, whoever that is. And then if necessary, they're going to have the testimony of Professor Cover. And then the next motion is arbitrariness. Number 6 is motion to strike statutory aggravators. HAC, utter disregard, future dangerousness, and multiple murders. They have time allotted for these. Look. Maybe I can move this over. I know it's funky because I have it set up for the video. But see, they have times allotted for all of these things. Number 7 is the notice and proof of non-statutory aggravators. That's slotted for 20 minutes. Then we have the motion to strike contemporary standards of decency. And then we have motion to strike speedy trial, lack of grand jury, and international law. And then we have the motion to trifurcate proceedings and apply evidentiary rules. So that's what is happening. So we're going to have, let's see who's going to be there. William Thompson, Santa, and Ashley Jennings. Jeffrey Nye and Ingrid Beatty from the Deputy Attorney General. Ann Taylor. Alyssa Masseth and Jay Logsden for the defendant. Feisty Nana, welcome to Lawful Listener. Island Thrifties, OMG. So good to see you, girl. How are you? And then we've got Eric Fredrickson as well as a public defender. Then we're going to be under the Honorable Mark Monson. I thought it was Hippler. I guess they got a copy of it. I don't know who Mark Monson is, but it's here. Stephen Hippler, Administrative District Judge. So let's add these up. How long are we going to be here? Let's see. That would be like 1 hour, 2 hour, 3 hour, 4, about 5 hours. This is an all day thing. This is an all day thing, y'all. Globalism. Good to see you. Heavenly. Hello, beautiful. Rakin. Good to see you. Newfie. Good to see you. The gang's all here. So I'm thinking this is going to be an all day thing because it's already 11 Eastern. So that gives you an idea of what to expect. Kind of like they did this. It says these limitations are per motion, not per side. In the event more time is needed and the motions cannot all be heard in one day, the court will continue on the 8th. So we may be continuing this tomorrow. They said if more time is needed, they will go on and continue it tomorrow. So we may be picking this up tomorrow as well. So again, the first thing we're going to hear about is the motion RE street clothing. And then it's going to be Dr. Wolf. Dr. Wolf, we've got 2 minutes until go time. Thank you guys all for being here and joining. And you could watch this anywhere and you're choosing to watch it here. And I appreciate you. Hey, Sassy. Good morning. Good to see all of you guys. Thrifties. Fuck you been, girl. Hey, Kami. Good to have you. Ganja. What's her name? What's her first name? Barbara Wolf. I want to see what she looks like. Because I don't remember her from OJ, but maybe if we see her. OJ. Who does Kohberger think he is, anyway? Hiring one of OJ. This is her. This must have been her back in 95. She works as a medical examiner in Florida right now. I wonder what county she works in. Wolf, who currently works as a medical examiner in Florida, was enlisted in Simpson's case, resulting in the former NFL player getting acquitted in 95. She's a forensic pathologist. She worked with a team of experts from Albany Medical College analyzing evidence in Simpson's case, including at least one of the 2 gloves found at the crime scene. She was behind the gloves. Oh, thank you so much, Sassy. Coke Zero Fund coming in hot. Thank you so much. That is so generous. I really appreciate that. Let me fix this. Thank you so much. You guys are so cool. So she was analyzing this, the glove. If it doesn't fit, you must acquit. Island, that sounds amazing. Wolf's team analyzed at least one of the infamous gloves found at the murder scene. Okay, so Wolf said last month that death by firing squad causes pain and suffering, according to an affidavit filed by Kohberger's lawyers. She's going to be remotely testifying. So yeah, she's gonna testify that firing squad causes pain and suffering. Kohberger's lawyers argued that he shouldn't face either method, the lethal injection or the firing squad, claiming Idaho has struggled with lethal injection, and he's saying that firing squad is cruel. So that's what she's testifying about. Barbara Wolf. Oh wow. So she's the medical examiner. They haven't started yet. She's the medical examiner for Citrus, Hernando, Lake, Marion, Seminole, and Sumter counties. Wonder if she has. Oh, does she? In 91, she was involved in the exhumation of Medgar Evers, the civil rights leader who was shot to death in Jackson, Mississippi in 63. In 95, she was involved in the exhumation of the bodies of 5 children from one family who were presumed to have died of SIDS. The reevaluation of these deaths led to the conviction of the mother for the suffocation of the infants. That's pretty crazy. In 94, she joined the highly regarded team of experts working on the O.J. Simpson double homicide. Dr. Wolf has also worked with a group of other forensic scientists in Croatia and Bosnia to assist in the identification of the remains in mass human graves. She subsequently testified before the U.S. Congress's Commission on Security and Cooperation in Europe. This is Barbara Wolf. Can't say I remember the face. Can't say I remember the face. Again, thank you so much, Sassy Hound. That was so generous. Cooter Scooters, my petty. I'm 4 months. I'm just so honored to have you here, Petty. I love you. I love what you stand for. And you captured my heart, girl. Yarn girl. Hey, Jay, the first hearing is closed. Street closed, so it might be starting later. Oh, thank you for letting me know that, Yarn girl. Thank you so much. So the first hearing is behind closed doors. The street clothing at public hearings. Oh, I didn't even see that. It says closed. But we should be beginning shortly, I would imagine. But they did say if these go further today, if they don't get through all these today, then they will be doing it tomorrow. Oh, do I need a new Discord link? Let me get.
Jennifer loves horses.
Whoops, I didn't mean to hit that. Hey, note to self. Good morning. Note to self, I want to thank you for your generous donation of pizzas and coffees and Coke Zeros the other day. It was very nice. Let me get y'all a Discord link. I don't know why I keep making it so it doesn't expire and then it expires. So it's definitely not on purpose. Invite. Copy link. I'm going to put it in the chat right now. Okay, there it is. Oh, Potato got it too. Well, there's two of them. How about if I pin it? Why won't it let me pin? Has my name always been yellow in here when you guys see it, or is that something new? Okay, so now we ain't got nothing but time. Oh, thank you so much, Potato, for working that out. It's always been yellow. I wasn't sure. Sophia Petrillo, thank you for donating a membership. Heavenly. Oh, I can't think of anyone more beautiful to receive that gift. Good morning, Lovey. You know who we're missing is Crimes Have Consequences. Where is our girl? Note to self, it says, you're so welcome. I adore you and your mods in chat. You're so sweet. It's really nice of you. Good morning, Miss Sherry. Heavenly says, Sophia, thank you. I know that was really sweet of her. I hope you guys are all doing well this morning. We've only got a little bit to wait because this was supposed to start at 9 o'clock. But yeah, if this goes over into tomorrow, we will be definitely covering this tomorrow. Aw, Sassy, that's really nice of you to say. And you're right. I'm very blessed to have the people that I do here. You guys are all very good people. You guys are all very sweet people. You're kind to one another. Do you know that we literally had no fighting in the political election thing? Do you know that no one fought? I was like, what? This is amazing. We had a bunch of adults that night. It was so nice. It's been a long day already. You had a bad day. Da-da-da-da. I don't know how that goes. But no bad days. No long days. The days have been really long, though, ever since the time change. Wait, I missed Island Thrifts. Hold on. Let me go up here. Island Thrifts rejoined. Thank you so much, sweetheart. Feisty Nana. Thank you so much. Fam. I missed you guys. Thank you so much for joining. And nobody in here gives a flying fuck if you bought lottery tickets. Oh no, I hope that everything goes well. Okay, Sherry. It is the time change. We've missed you, Island. Trixie, hey, how are you? Ember, that is nuts. No one should be freaking fighting over politicians. I find that to be so silly. You know what? My family did the same thing. I have siblings that won't speak because of Donald Trump. It's like, what? What are you going to do? Like, what are those people going to do when they pass away? Like, I mean, I'm just saying everyone's going to die someday. I'm not trying to be like weird about it, but eventually, hold on, I'm trying to fix this. Eventually, we're all going to pass away. And then if you go back and you're like, oh, when was the last time I talked to my brother? Like, oh, I told him to fuck off because of Donald Trump. Like, you're going to feel really dumb. There's going to be a lot of people feeling really dumb and carrying around guilt, in my opinion, because I just think that is the dumbest thing ever. Because if you call up Donald Trump right now and say, hey, do you want so-and-so to fight with their family over you? He'll be like, who? He'll be like, who? Who dat? Uh-oh. Your son has pneumonia? Oh, no. Sending all kinds of good vibes and prayers to Island's little boy. Dr. Melmo, I'm not here to give out names. Outright attacked me over text when I ignored her social media attack. That's crazy. Sophia, thank you for your $5 super chat. I had a blast election night with you. I'm glad you were there. Thank you so much. Hey, Micro Kim. Everyone has different circumstances. They shouldn't be judged on how they feel. Yeah, but people get mad, like defensive over. I mean, it's both sides. I'm saying, like, people get defensive over Donald Trump and be like, oh, if you're going to say this, like, I'm not going to fucking talk to you. Blocking each other and shit. I can't. It ain't worth it. No one is worth fighting with over politics, in my opinion. Anywho, court will be. Oh, the screen changed, guys. Here we go. I'm going to put it back on this right now. They opened it up, so that must mean that we're getting close to starting. If you guys have not hit the like button yet, now would be a great time to do that before
Bryan Kohberger
enters the courtroom. We have Summer Lou over here on Doggy Cam. Here we go. Perfect timing. There's Kohberger. There's Kohberger, y'all. It's really quiet in there. I keep forgetting we're in a different courtroom. How awkward. Look at Brian. He's not moving. He's like a statue. That's okay, Petty. You should be on the innocent side until proven guilty anyway, right? I bet he smells like all views are welcome here. Yarn Girl, welcome to Lawful Listener. Welcome to the Clickers. Thank you for joining.
Man, I'll tell you what, that dang old internet, man. Click, 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 click. It's real easy, man.
Look at those hands, y'all. Damn, he's got some hands. Thank you, Carrie. Hey, Heather, you're just in time. It's just now beginning.
All right, we are back on the record in Ada County case CR 0124316665, State versus Kohberger. Counsel are present, I think with the exception of Mr. Logsdon, is that correct?
That's correct, Your Honor.
Is it loud enough or do you need it louder?
And counsel previously identified for the state are present as well. Is Mr. Thompson going to be on the? Okay. All right. So Mr. Thompson is appearing remotely. This is the time set for a number of hearings this morning. Yesterday afternoon, I issued an order by which the proceedings would be handled, the order in which that they would be handled, as well as designating the amount of time, generally speaking, that the parties or that the court will devote to the issue. The court has received extensive briefing by both parties and has reviewed it all thoroughly. So the first thing I want to address, just because the public was not here this morning, I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes. The first matter we have to take up this morning is the objection to the testimony of Dr. Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
Your Honor, would you like me to address?
Podium, please.
Yep.
I like this judge, and I like this setup, and I like that the audio is
Your
good.
Honor, our objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not ripe before we have an evidentiary hearing on it.
All right.
That's the extent of the objection.
All right.
Thank you, Your Honor.
Island,
Taylor?
did you follow Sarah?
Thank you, Your Honor. Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Kohberger's ever convicted, and if there's a death penalty, and if he faces the firing squad as one of the options.
Well, I also am not particularly convinced about your, well, I'm going to save that till we get to the merits of it. Let's talk about whether we need to hear from Dr. Wolf first, so I can continue.
Your Honor, I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering, which matters for the Eighth Amendment, as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023 instituting it again. But this information about consciousness of pain and suffering happens in that window between 2009 and 2023, and I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you. Any rebuttal?
Very briefly, Your Honor. I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right, thank you. All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be. that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right. So let's hear that from the defense.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration. The information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf, that's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Oh,
Say
Lord.
there's no means, under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. Not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their...
have obtained them twice now, since then.
He cut her off.
They've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm
doesn't
looking
have a
at when I'm
death
standing
pen- what?
before you,
Scheduled?
representing Mr. Kohberger, and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision, and you look at what's happened since the Bays decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least, that the construction's actually underway, but I may be wrong about that.
They're building a firing squad thing?
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you, Your Honor.
Can I ask you, even if your motion were right, and even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual, how do you get around Buckwell? You've not provided an alternate means of execution.
Well,
and I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition precedent, provide a available or an alternate, I should say, means of execution.
I would say to Your Honor that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that involves, all of the requirements that are upon counsel that take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction, and if there was a death sentence, and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence, because the current methods, in your view, are either unavailable or unconstitutional? But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then? And, I think that's part of why you're saying you shouldn't have to comply with Buckwell, but it seems to me that that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time.
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years, when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion, and I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
And I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit.
Well, I said
And no
a
disrespect to
decade,
the anxiety Mr. Creech
He's
felt.
like
I
a
think that must have
decade.
been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Okay. Thank you.
Let's see what the judge says.
Aye.
Ultimately, that's all that matters. So, no sense arguing.
I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging, and then after he was sentenced to death, the state passed a law, made it electrocution, and the U.S. Supreme Court said there's no ex post facto problem with that because you're not changing the penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this, and certainly not that it can't do this decades from now. And again, that gets back to the ripeness issue is it may be lethal injection, it may not. It may be some other method. But we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the ripeness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. You know, what I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today in argument, what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do this other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
Look at that picture, y'all. Damn. He's like,
Just briefly, Your Honor.
shut the fuck up.
The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute. I understand.
Any case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about two pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you.
I'm with you, Lucid. That whole thing confuses me. I hope the trial tells the story, unlike Delphi trial, right? We want to know what happened. Hopefully, this trial tells that story.
All right, court will take that issue under advisement and issue a written opinion with respect to its ruling. Next, I want to take up the objection to Professor Kohberger's testimony.
Your Honor, as the state pointed out in its written objection, Professor Cover's testimony is
Is it
largely...
cover or covert?
I believe it, I'll defer to defense counsel. Is it?
It's cover.
Cover, thank you.
Thank you, counsel. Professor Cover's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received the PowerPoint that Professor Cover would be utilizing, many of these slides are simply excerpts from statutes. This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Pass off.
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination. And so that's my first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it.
Smiley McSmiley.
The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty. that that's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided.
And that I'm a trial court and not the Supreme Court.
And I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That was
capricious
the claim of
application?
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban versus
That's
a
different from the
non-urban.
issue of what the relevant legal framework is with respect to whether or not the aggravators
You're
are
being a
overbroad
Karen.
or over-inclusive.
I
as a
agree.
whole.
I agree, but before we get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote-unquote the fuzzy ones, I think is what she called it, and then the, I can't remember what the name.
Clear.
The clear ones
Right.
were.
Right,
Duck
but
and
it
fuzzy
is
slippers
her
and
study
lip
is a good
balm.
foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right, but I guess my concern is that the Supreme Court, the Idaho Supreme Court, has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask with that respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's-
But it begins, Judge, with the definition of first-degree murder. You start with the definition, which is very broad, of first-degree murder,
Which is why the
Murder.
aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Culver's article.
No, that's true, but it still comes to issue, you still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I mean, everyone agrees the statute itself as to first-degree murders that are eligible is, without more, unconstitutionally vague. That's why the court has, U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first-degree murders from it? Does it narrow first-degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor Cover's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she says.
That's the purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, you know, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Cover. Why can't I rely on her law review article as a proffer of what her testimony would be?
Nay.
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, you know, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
And you know what I have to say to Ann C. Taylor, the defense lawyer? Bring it on, woman.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case, and Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular, and potentially others, as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply? The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice, again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping, but again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the State Appellate Public Defender's Office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
You want a cough drop?
Rebuttal? Oh, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you for,
Thank you.
my schedule is already shot to hell, but
I'll indulge you.
indulge you.
Oh, shit.
we will be able to get through in one day. I think that the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. First of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. If she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so.
And that law review article was as of 2019?
Yes. Yeah. Yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So you, since I have you, you brought up Hidalgo. and you talked about the Supreme Court doing this, my reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An
because
invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Thank you. So
Interesting.
I don't find that the proffered testimony of Dr. Cover will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to the court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful
Denied.
and therefore not admissible. Importantly,
Look at Smiley. She's not
of course, as
happy.
we talked about, Idaho has opted to satisfy the constitutional
Brian's
narrowing
pissed.
requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Cover's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. And therefore, I don't feel the need to take Dr. Cover's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Cover back at a later date to provide that information or to help clarify some of that information. So from that perspective, I don't think Dr. Cover's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Cover's analysis, because certainly counsel has the right to make a record of their argument on that as well. And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
UA. Listen to UA, everybody. Hit that like button. Oh, here comes Smiley again. Look at the judge. He's like, okay.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
Your argument doesn't consider the weighing of mitigators against the aggravators, is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection
Right.
phase.
That's what I'm saying.
So I'm not arguing about
He's
that. I'm gonna
definitely
step
playing-
and grab my water.
Sure.
He is playing chess with her ass. Oh my God. Did you see him roll his eyes? And yeah, the judge and the prosecutor look like they're brothers.
I
Holy
want
crap.
to be clear about the argument and eligibility, that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor, in their discretion, they're looking at, and there's essentially no guidance with the first-degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a
Say that
binding,
3 times fast.
opinion of the court.
Specific
There's
to
much
statistic.
more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse, and so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is
Oh, boy.
the analysis by Dr. Kover in her extensive law review article.
Look at the state
Takes
prosecutors.
as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse.
Next. What's going on? This is weird.
So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors, and I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or an other officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until, it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography, and I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harriston over financial resources, and the point was geography. It was in the context of arbitrary and capricious, and not in the context of equal
But
protection.
as I understand your analysis, is that the there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's statutory
Oh, boy.
scheme.
On the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at
Jesus,
a
lady.
state level, and it's geographical at a national level.
Island, you are cracking me up.
Interesting, I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho,
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, and then I believe there was another one up in the 2nd District relatively recently that then was resolved.
and I can't dispute that. That still does not eliminate the fact that in Hairston, Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. The
judge's face.
For those
Oh, my
reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If
names.
I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at the cases since 2019 as well?
I think, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that, needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
timeframe.
opinion about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Look at Kohberger's.
Well, it could certainly be instructive, Judge, but, if you're taking the data from Hairston, which was 1978 to 1995, and Professor Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it, we could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory
Oh my
aggravators.
God.
You're what the French
A
call
case that
les
indicates that
incompetents.
an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So, yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that. But I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say
And rejected
you're
in
the
those-
first.
in all of those.
Right, but it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the, does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Otherwise, get treated like scum.
You've used your time.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With cumulating and then,
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first-degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, you know, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. You know, the defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today, and the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason, and that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder, and that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of Tulipa as interpreted by the Idaho Supreme Court,
Tilapia.
even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, you know, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on would you have to look at the data up to today? I think the question, or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say that courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors, so now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do so. I just wanted to know. You were fairly summary about it. And it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas because just as a matter of statistics, there's probably going to be more first-degree murders committed there and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions, thank you, Your Honor.
Rebuttal?
Oh,
Judge, I just
Lord.
wanted to touch on the issue that he raised about Hairston and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing, and that really is a very important distinction because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
You know what year
Shut the
the
fuck up.
Capital Defense Fund was established?
It was after 95, and I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that, but I don't.
Mr.
I just know it was
Logston.
Has that
after
mitigated the
95.
issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first-degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you. I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
All right, so we're on break for 10 minutes. Can that lady not read the room or what? Hold on, let me get caught up on chat here. I was ordering I was doing some of my groceries. Yeah, so that I don't know why Jay's not there, Mr. Logston, but let's go over the itinerary for today, if you will. I don't know if that's what they call it. Proceedings. Okay, so what have we gotten through so far? Let's see. They did the closed one, and then did we talk about Barbara Wolf? I must have missed that. Yeah, everybody go get up and move around, get a snack, get a drink. They did say, the defense said, we will get through this today. They're Pacific time, so they're 2 hours behind Eastern right now. So I don't remember hearing about Dr. Wolf unless I missed it. I did hear the method of execution. We heard that. And then the professor cover. And then did we do the arbitrariness? Next is motion to strike statutory aggravators, or did we just do that? No, I'm not cold. It's really hot out. It's really muggy. Thanks, note to self. Did you guys hear about Wolf? Jay Lugs, yeah, he did, David. You were right. I thought they were Pacific time. Alexa, what time zone is Ada County, Idaho? Oh, it is. Thank you. I thought it was Pacific. Wolf was on the death penalty method and the not knowing causing anxiety. Oh, okay. Thank you, Lolly. So he denied that. He said it wasn't. She's not needed. Thank you, Yarn Girl. Thank you, you guys. Oh, I know. Wouldn't this be a great judge for BHB? No howling yet, Gopher. Okay, so Wolf was not needed. Ah, you learn something new every day. So we have actually 10 things, and it looks like we're on number 6, if I'm correct. No, I guess it is mountain time. What's the weather like where you are? Because I forget that it's changing everywhere. Like, it's warm here. It's, I don't know. It's not really sunny. It's cloudy outside, but it's super humid. Cold in England. Right, 911. I bet his victims had anxiety before they died, too. Heavenly, I know. You look so beautiful in green. Yeah, the judge is not going to mess around with their BS. Like, Judge, someone said earlier, like, Judge would just sit there and entertain it. A blizzard. Oh my gosh, Nicole. 53 and sunny. Oh, snow. 67, nice and crisp. That sounds like nice, though, where you can put on a hoodie. Warm and muggy in eastern North Carolina. 59 in Pennsylvania. 38 and sunny. 55 in Toronto. That's not bad. Humid where I am too. I forget seasons as well in Texas. I forget that people are getting snow now. 56 in Long Beach. Cold in North Idaho. Windows are frosted over. Oh. Your doggy is a sleeping beauty. Aw, isn't she? 24 and snowing. 54 in Ohio. Warm and muggy. 60 in Indiana. Warm, cloudy, and muggy in North Carolina. That feels like about the same here, Misty. Cloudy, warm, and humid. Sassy, thank you so much for your $4.99 for a snack. Sassy just bought me some snacks. Let's give it up for Sassy and her snacks. Where's my snack soundbite? What happened to it?
We bought snacks because, he's 15 and snacks.
Thank you for the snacks. Yeah, my air has not been off. Like, it's not that cool yet here. 57 feels like 54 in Wichita. 56 in Maine. 78 and muggy in North Carolina. 76 East Tennessee. 45 in Minnesota. Alabama is 78 muggy. 54 cloudy. Perfect hoodie weather. I like that. I'd rather be hot than cold. Same here. 84. It is depressing. 36 in Utah. Wouldn't be bad, but it was just 82 a few days ago. Oh my God. Everyone in this courtroom today, 45 in the UP. Wow. 31 this morning. You guys got snow yet, Kay? Your furnace is on? Sassy. Yes, it's so humid here. 34 and snowing hard. 67 in New Jersey, Franny Melville. I don't know, Bomba Trucker. I'm still trying to figure that out myself. It can be hot as Hades. And JLR is out there in a hoodie. I don't know how he does it. I'm not New Jersey 76, but chilly breezy. That doesn't sound too bad, Lucia. I really like being hot rather than cold. I have a hard time warming up when I'm cold versus cooling off when I'm hot. So I'd rather be able to go into like the AC or whatever, or jump in the pool, cool off. But when I'm cold, oh, it's just miserable. I just have such a hard time getting warm. 51 in Montreal, Naomi. 76 in miserable. Yeah, my air is on too. My air never shuts off unless it's cool. Like today, let me see what the temperature is. Let's see. I don't know what the temp is. It's deceiving when it's humid like this, you know? Why didn't it? Let's go Clearwater, Florida. Why does it keep doing that? Finicky thing. So it says it's 82. Overnight 73. But the humidity is 70%. It feels icky out there. So I guess that hurricane is going up to Louisiana. Whoever is up there, stay safe. Like they haven't even talked about it, but I know it's heading somewhere. So yeah, Pearl Strand, it's like I hate being hot, too hot or too cold, but a few inches last week, Kay. Wow. The Kiki's got the wood stove going. I love that. It's so cozy. I'm not going to say her name, went off when you did that, and I'm in the UK. Christine, that's crazy. I think it's going up to, like I said, I think it's going up to Louisiana. Mild and damp in the UK. Isn't that par for the course, Christine? Shamrock, you're the same way. Damn, furnace is on already. Bayou, is it coming towards you? I thought it was heading up to Louisiana. Lovey and Bayou. I could have sworn that Raphael was heading up to Louisiana. Didn't they say it would be a tropical storm? You know, I haven't seen anything about it, to be honest. I saw that it wasn't hitting us, and it was heading towards Louisiana, and that's the last that I saw. It probably would weaken. I mean, we all have PTSD, so they don't want to talk hurricanes that aren't a threat. Yeah, that's probably a good idea. Oh, they said it will dissipate in the Gulf. Thank God. Miss Robbins says we are still having trees fall down from Helene. Lost power last night from trees falling. Wow. Me too, bad girl. Me too. We should be back in court just in a minute here. Thank you for chatting with me, and thank you for being here today. It's nice having y'all here. I'm going to turn off this pink light. Does it look different now? Because I turned off that pink light. It's going to turn south and hit Mexico. Yeah. Okay. Hopefully it dissipates. Yeah. Amber Gloria said, I tried to find it on the news this morning. All different map predictions. Jen says it's 69, sunny, breezy, and humid here in Connecticut. Wow, that's warm for Connecticut, isn't it? Y'all aren't the misfits. They have it going towards Mexico. No wonder we're not hearing about it. No wonder. So they're 2 hours behind us. Right now it's 10:47 there. If they go till court closes at 5, we could possibly be here till 7 p.m. Possibly. Heavenly, I'm so glad you're here. And you, like I said, I love seeing you in green. I'm getting used to it. I have to get used to it. It looks good on you though, girl. Are you guys still munching on Halloween candy from your kids and stuff? Or are you sick of it already? Oh, speaking of Halloween, I got to get rid of that Halloween music. That was so stupid. I keep forgetting. Every stream, I keep saying, okay, I got to change it. And then when I'm done with my stream, I have other things to take care of, so I forget. Sunny and 54 in Wisconsin. That is not bad. What a nice fall day. Oh, God. 911 crime time. I just discovered my daughter broke my MacBook charger again. Oh, my gosh. I can't tell you how many of those I've had to buy. Good morning, Ryan Applesnapple. Good to see you. How did the interview go? You must let us know. I'm a poet and I didn't even know it. How did the interview go? You must let us know. You must let us know right now. Eating all their candy. On a diet, no candy. The interview went great. Good to hear. I've got a bag left and only eat it when I have the gummy munchies. Robat? I kind of miss Robat. It does, doesn't it, Lisa? She said, I love Halloween music. I think it fits the bill for true crime. I bought candy 50% off for myself. Good for you. Oh, man. We're almost back to Judge Hippler. Judge Hippler. I like Judge Hippler. Put a 1 in chat if you like Judge Hippler. I was looking at the Halloween candy. Where was I? I don't know. I was at some store and they didn't have anything good left. Like the 50% off. It was all gross stuff, like weird stuff that nobody wants. Any Richard Allen court update? I think they're doing closing today, so I haven't seen anything. Let's see. We can find out really quick. Okay, today's day 18. Today's supposed to be closing arguments in Delphi.
Today's closing arguments are the last chance for both the prosecution and the defense.
I just want to see the Okay, at 12:10 the defense completed its closing argument. They are at lunch, and after lunch they're going to give their rebuttal. The jury is going to get this today. So that was pretty fast. Let's go down. Wait, hold up. We're not back yet. I'll keep an eye on it. Oh, there's a lot to read. Okay, so at 10:34, court began. Judge Gull talked to the jury. Before court begins, News 8's Kyla Russell reports that defense attorney Andrew Baldwin writes Rick on a coffee cup and gives it to Alan. Normally, Alan gets a coffee from the courthouse, but today Baldwin has purchased one from a local shop. Alan enters the room. Russell reports that he has a regular large-size Bible today and not the typical Gideon-style Bible he's had in the past. He is heard saying he loves the coffee, and he shows defense attorney Jennifer Oger a verse in his Bible. Prosecutor Stacy Diener is seen hugging the German and Williams family members. Abby's mother is crying and being comforted by family. That was before court. So the prosecutor went over Bridge Guy, the bullet, and the confessions. I'm not going to read all this right now. And then at 10:24, Rozzy began the closing argument. Rozzy says there's 4 main themes: a broken timeline, bumbled ballistics, false confessions, and digital forensics. The closing arguments are going to be so telling to really lay it all out. So, yeah, that's the latest for today. "911 crime time." No, I haven't paid attention. I mean, I have a little bit, but I haven't watched it. Yeah, she's been going live a lot lately. She's getting that backup channel rearing because, she's probably going to jail. Oh, you watched the lunch live. She was wanting to cry. How come? Today's Gypsy's birthday. Oh, excuse me. Happy birthday, Gyps. I know we did this the other day, but we're doing it on your actual birthday. And Heavenly, this is for you too.
Go, shorty. It's your birthday.
Happy birthday. Bullhorn Betty might be going to jail. She said it was very emotional. I hope you have the best day ever, Gypsy. Thanks, everyone. Oh, I heard it, Bama. It was great. I was in the chat. I was like, I had to come out of the bushes to say something about that one. I was like, go Chico. I never heard of Chico before yesterday. I was like, she was spot on. Hey, Chris. Be careful driving out there. JP Miller was arrested now? I knew that the FBI was in there. Was he arrested? Summer, what are you doing? What are you doing? I didn't follow that case. I mean, I know what happened, but I didn't. Did he get arrested? Oh, he did. Oh, arrested for assault and battery. Oh, shit. Okay, we're back in court. Thank you so much, Sherry. Oh, that is so generous of you. Thank you so much for your $20 super sticker. Oh, wow. Assaulting a protester? What a douche. I have a feeling this is just the beginning of his troubles, though. His mugshot? Let me see.
All right, I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes, and you can address them in whatever proportion you like within that.
Here comes Smiley McSmileson again. Oh, God.
Okay, Judge, I will be covering heinous, atrocious, and cruel utter disregard, and then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next 3, and given the time that you've asked, I'm assuming there will be less questions, maybe?
I will try to restrain my curiosity.
I'm happy to engage with you.
As you know, I gave you some additional time, and that says why.
Right,
Why.
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arave versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, you know, Hall was, a decision was issued in 2018, so was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, "This court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction." And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, you know, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator, as arbitrary and capricious.
Oh my God, lady,
and so we are asking that you take into consideration the way that we are framing this argument, which is different than it was in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, you know, similar. Yeah.
McNo.
Oh boy, this is not going well for the defense today.
So let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth,
He's got her coming back up.
they can take notes.
Same.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raised the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim
loaded.
aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Literally
Isn't it
poking his
more
eyes out.
culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree, and
Right.
right. And the floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so, just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's, the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
Trick question.
Becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators.
He put his
I
middle
also
finger
wanted to
back
point
up.
out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multi-aggravator as well.
You buzzed?
Yeah, okay, now here comes Ann Kohberger.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says people.
Did Hall say that it was okay? I can't remember if they addressed that in Hall. I think
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And
Isn't that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square
The
in
only
my
danger
mind
is your
how
client, ma'am.
I am to do my ethical
In his
duty to my
hand.
client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over, like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That
Would you want those hands near you?
That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the Eighth Amendment.
Thank you.
Rakin. I would say no. Y'all can think, I mean, you're welcome to have your opinions and thoughts and theories. No worries.
Your Honor, beginning with the heinous, and atrocious, and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was Hall a jury determination? Do you know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall, because that issue hasn't come up. But
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all, and that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial gloss. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on an independent basis for each of these aggravators during the penalty phase. That's our legal obligation, and the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah. I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislatures, not the judiciaries. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity and those two so overlap that you can't have both, you could still have one. Or you could have both, but if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi-aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
I heard Largo with like a G.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or it's probable that they would kill again. I think is the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, That's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction, or with this aggravator. It needs to be fixed. But the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
Jesus, that's loud. The judge's face is so funny. Have you guys hit the like button for me yet?
All right, I think the non-statutory aggravators is the next issue for our attention. And so with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the state on that issue?
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being...
So if you look at it like a scale, right? And defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor, and I think that that's clear from the Hall decision when they talked about this. They talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process.
Those hands aggravate me.
I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented, when weighed against each statutory aggravating circumstance proven by the state, are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance, and that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. Now, we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for, and I think that that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background,
Look at
that's
Ashley
where
Jennings.
it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters, but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you.
Oh, God, I'm losing my mind already.
All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well,
Your Honor, can I help on that?
yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can
Jay.
cover it, but he's really close.
So he's not here. All right, well, let's start
Jay
then with
still
8
isn't
contemporary
there.
standards of decency.
It's 11:35.
That's the one that Mr. Logston
Oh, he is.
would be here. I've got Speedy.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So
Jay's
you've got
not
Speedy?
there.
Let's start with that then.
I can do that. Thank you, Judge.
Oh, Jay, where the hell are you?
Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute, 1935-01, says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me.
So it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months. But I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of Speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. during the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial, and that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment, they do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute, to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. I think the court can and should strike the death penalty in this case based on the record
That would
here.
result in the death penalty being struck in every case.
Your Honor,
Oh, you
if
just
that's
lean back.
the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing...
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why
Oh,
can't
yeah, he
it,
is there now.
expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
Hey, Vanna.
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the, be more flexible given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job
what...
as a district judge, if there's not an issue that has been decided by the court, is
Get her,
determine
Judge.
how that court would decide things.
Well, I think you can consider what Judge Boyce did in the Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other.
Hey, Brune, welcome in.
But in this case, the decision to waive speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that
She doesn't
this
sound very
motion this day
confident
was
anymore.
coming. we don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial, and so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
She got really quiet. She kind of backed off. What'd she say? I'm glad you made it.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case,
I thought we had a
Well, and that was my point in, perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. And that was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today, because
my point is that's, I think, what this defense is arguing, essentially.
Yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period. And regardless of whether they want...
The argument that the 6-month is functionally equivalent of the twice a year...
Who is coughing in there?
...circuit.
If that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So... under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But
Welcome,
the court
new members.
easily could have said, well, he asked for a delay, so his constitutional right was waived. But they didn't, because that's not how it operates. So The real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible, and one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Thanks for being here, guys. Enjoy your memberships.
Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so,
Well, doesn't speedy mean the Barker test?
well, at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. So that's it.
I agree with that, globalism.
All right. That, along with the other motions, will be taken under advisement. Let's take a lunch
being a
break. It's
Karen.
5 to 12.
Lunch break.
Adjourn at 1 o'clock. Thank you.
All right.
So we've got an hour and 5 minutes. Caitlin, if it's frozen for you, you might need to leave and come back. I don't think it's frozen for everybody. Hey, Peppy, how you doing? You came in just in time for them to take a lunch break. So they're gone until 3 o'clock Eastern. Let's see if we've got any Delphi updates. Let's read through these. For those of you following Delphi. Oh, Richard Allen. Oh, wait, that's old. Sorry. We have to go to today's day, which is closing arguments. Let's see what's going on there.
Breaking news in the Delphi murders trial. The defense has wrapped up its closing arguments. Let's get.
All right, we already knew that. Oh, shit. 1:40 p.m. Okay, so just about 15 minutes ago, the case went to the jury. And they are picking a 4-person right now. Now, what's interesting about this jury, I don't know how to turn this off. How do I? Okay. So the interesting thing about this jury Bitch Franklin, are you blocked? I'll definitely unblock you. They're choosing a foreman right now. At 12:10, the defense completed its closing argument. And then after lunch, they gave their rebuttal. Now it is in the jury's hand. 1:40 p.m. It has gone to the jury, and the jury is currently in the process of choosing a foreman. Damn, man. I wonder how long it's going to take. Candy Wrapper, I talked to CL not long ago. I told you I went to school with her. Oh, that's right. That's right. Is CL still testifying? So in the closing arguments, and obviously we'll hear more about this tonight, but let's read through these, shall we? We have time. All right, so that's a summary of yesterday. Okay. Let's do this. I like that the jury was able to ask questions as well. Okay. 9 a.m., the court was in session. After 17 days of witness testimony and evidence being presented, the jury will hear from both the prosecution and defense. Special Judge Francis Gull told the jury Wednesday they would hear several hours of closing arguments. The judge told each side they would have up to 2.5 hours. Both sides will only be able to talk about the evidence and testimony that was admitted during the trial, which means the defense team will not be allowed to bring up Odinism or any of the third-party suspects they claim actually committed the murders. When closing arguments are over, the jury will be given instructions. If they have reasonable doubt, they are instructed to find Richard Allen not guilty. If they believe Allen committed the murders, they are instructed to find him guilty. After that, it will be up to the jury. Deliberations could take hours or days. The 12-member jury, 3 alternates excluded, must reach a unanimous verdict. If they are unable to do so, the trial could end in a mistrial. Before court begins, News 8's Kyla Russell reports that defense attorney Andrew Baldwin writes Rick on a coffee cup and gives it to Allen. Normally, Allen gets a coffee from the courthouse, but today Baldwin has purchased one from a local shop. At 8:47 a.m., Allen enters the room. Russell reports that he has a regular large-size Bible today, and not the typical Gideon-style Bible he's had in the past. He is heard saying he loves the coffee. He shows defense attorney Jennifer Oger a verse in his Bible. Prosecutor Stacy Diener is seen hugging the German and William family members. Abby's mother is crying and being comforted by family. At 9:04 a.m., Judge Gall enters the courtroom. The jury enters at 9:07. Court is in session. Gall says the jury again had supervised contact with their electronic devices. She explains some of the case-specific jury instructions. 1, the jury must follow all law while deliberating. 2, the jury must consider all facts. Gull reads all the counts against Allen. He shakes his head as Gull reads charges that say he killed AW and LG. She explains the concept of beyond reasonable doubt and the definition of murder. Gull explains that if the state proved beyond a reasonable doubt that Allen killed the girls, they must find him guilty and vice versa. Gull explains intentionally what it means. Now we move into the prosecutor. 9:17 a.m. Prosecutor Nick McClellan begins closing arguments. He tells the jury that February 13th is a day Delphi will never forget. He says the state has proven that Allen is the bridge guy. He tells the jury, quote, the state has done just that. McClellan talks about the day, where Libby was the last time she talked to Becky Patty, Libby's grandmother. He is showing the jury a PowerPoint with Libby and Abby's Snapchat photo from Kelsey German's car. He recounts the search Libby's father made and how he called Becky Patty. McClellan tells the jury about the search and that Brad Weber, the neighbors, let them look around his property. He says he did not look through the house at that time, however. McClellan goes through the testimony of several people on the bridge and in the area that saw Bridge Guy, from Betsy Blair, who saw the girls, to Sarah Carbaugh, who said she saw Bridge Guy, quote, muddy and bloody. He says, quote, that doesn't happen around here, referring to the murders. He describes the bodies being found and shows photos of the girls' clothes in Deer Creek. He describes the crime scene being secured. McClellan shows the jury a photo of Libby's phone. He shows the Bridge Guy video from February 13th, 2017 at 2:13. He says, quote, the video shows the moment they were forced down the hill by the guy in the video, Bridge Guy. He forced them down the hill with a gun. He says Libby said in the video, that be a gun. He shows the jury an enhanced version of the Bridge Guy video. McClellan says law enforcement interviewed people on the bridge that day. He shows a photo of a witness. A witness took a Freedom Bridge. He recounts Bree Wilbur saying she saw a man on the trails, quote, walking with purpose. He shows the jury Betsy Blair's Fitbit information. He talks about Sarah Carbaugh seeing a man muddy and bloody on 300 North. McClellan talks about Chris Cecil's forensic examination of Libby's phone and how he got health data from it. He says that data confirms when the girls were at the bridge. He says GPS shows when movement was at 2:32 p.m. and that there was no more movement after that. He goes over the timeline with witnesses, when they arrived, when they went. He says Breanne Wilbur arrived at Freedom Bridge at 12:25 p.m. that day and walked to the high bridge. She took a photo at 1:26 p.m. at the bridge. He says she ran into Bridge Guy while walking back to Freedom Bridge. McClellan tells the jury about Betsy Blair passing a camera at the Hoosier Harvest Store, heading to the high bridge. He says Kelsey German's car was also seen on that camera, passing it after she dropped off the girls. He says Blair saw a man on the bridge and passed Libby and Abby as they arrived on the bridge. He says Bridge Guy video was taken at 2:13 p.m. He tells the jury Libby's phone stopped moving at 2:32 p.m. He says that Sarah Carbaugh passed the Hoover Harvest Store at 3:56 p.m. and she saw a Bridge Guy and he was muddy and bloody. McClellan says, quote, if we can determine who Bridge Guy is, we can determine who killed Abby Williams and Liberty German. McClellan moves ahead to 2022. He describes Kathy Shank finding the lead sheet regarding Allen. He describes Shank taking the tip to Tony Liggett, a detective working on the investigation. He describes conservation officer Dan Doolin downloading a photo of Allen from the BMV. McClellan says it was determined that Allen's car was the only 2016 black Ford Focus registered in Carroll County in 2017. He says former Sheriff Steve Mullen went to the Hoosier Harvest Store and got footage from the camera there of Allen's Ford Focus at 1:17 p.m. He says that on October 13th, 2022, Mullen called Allen in for an interview. He says Allen confirmed that we was wearing... What? He says Allen confirmed he was wearing the same clothes Bridge Guy was wearing. McClellan tells the jury that Allen said he saw 3 girls, but in the interview he changed the time he was there. He said Allen became angrier as the interview went on. He shows the jury photos of Allen's Ford Focus in the garage during the search of Allen's home. He says they found the blue Carhartt jacket in Allen's home. McClellan says, quote, surprise, surprise. I got to stop here for a second. If they have the actual coat, were they not able to get any DNA or any kind of evidence from his actual coat? And he says, surprise, surprise. McClellan says they found the 6-hour 40 caliber handgun and cartridges that were the same brand and caliber as the cartridge found at the crime scene. McClellan calls it a, quote, bridge guy starter kit. He says they found a memories box, and that box contained a 40 caliber cartridge. He says investigators found many electronic devices, but not the phone Allen used in 2017. McClellan tells the jury that Allen searched "Should I Die Now?" after looking at Delphi News in April of 2022. He tells the jury that Melissa Oberg found the cartridge at the scene, cycled through Allen's handgun, and her work was verified. He says Allen confirmed in an October 26, 2022 interview that he never loaded his gun or that he never lent his gun or clothes out to anyone. He said Allen confirmed he did not loan anyone ammunition. McClellan says, quote, there's no explanation for how his bullet ended up there. He says Allen's wife, Kathy, was brought in for questioning, and during the interview, Allen manipulated her. McClellan says Allen was arrested because he is bridge guy. McClellan talks about calls Allen made in prison to his mother and wife. He describes a call Allen had with his mom where he says he had found faith. He plays a call with Allen's wife where Allen says, quote, I killed Abby and Libby. His wife says, no, you didn't, dear. They are screwing with you, and I'm trying to get to the bottom of it. He shows the confession letter Allen wrote to the warden. He shows the report from Dr. Walla on April 5th, 2023, where Allen said his intentions were, quote, sexual in nature. News 8's Kyla Russell reports Allen is shaking his head during this. McClellan tells the jury that Walla said Allen's behavior changed after his attorneys visited and that the shift in his behavior was intentional and he was not psychotic. McClellan read multiple confessions made by Allen in prison, including one Allen made about using a box cutter to kill the girls. McClellan says Allen told his mother in May of 2023 that, quote, I wouldn't sit here and tell you I did it if I didn't. He talks about another confession that Allen made in January of 2024, after he had been moved out of the Westfield Correctional Unit. McClellan describes Brian Harshman, the officer who read Walla's reports and listened to Allen's phone calls. He describes Harshman discovering the detail about the white van Allen said he saw while committing the crimes. He said Harshman verified the owner of that van in 2017. He tells the jury that the owner of that van, Brad Weber, did drive it that day. He points to Allen and says, quote, something only the killer would know. Allen raises his eyebrows. McClellan says Harshman knew it was the same voice as Bridge Guy and all the calls he's listened to from Allen. McClellan shows the jury all the charges, which include charges for felony murder for killing Libby and Abby. He tells the jury, quote, now the pieces come together. McClellan says Bridge Guy, quote, stole the youth and life from Libby and Abby. He shows the Snapchat photo from Kelsey German's car again. He says something in Libby caused her to begin recording on her phone. He tells the jury that there was a pause in the health data on Libby's phone before Allen killed the girls. He says, quote, grabbing for her throat, struggling to stay alive, she begins to cry. He says Allen lived in the community for 5 years, but didn't know he left a cartridge at the scene. McClellan reviews 3 points. 1, Bridge Guy. 2, bullet. 3, confessions. Quote, I believe the evidence is firmly convincing that Richard Allen is Bridge Guy and he killed Abby and Libby, McClellan told the jury. After 58 minutes, McClellan finished. Now to the defense. Rozzi tells the jury they've been there for almost a month and have seen 17 days of evidence. Quote, the defense trusts what you've heard over the last several weeks. Rozzi says there are 4 main themes. 1, broken timeline. 2, fumbled ballistics. 3, false confessions. 4, digital forensics. Rozzi tells the jury that the state has presented a theme of, quote, what they don't want you to hear is what we had to tell you. He says, quote, we had to do their job, end quote. Rozzi expands on that by saying that the state refused to have height analysis done on Bridge Guy. He says hours of video interviews from 2017 were lost. Rozzi tells the jury the state had to look at a detail about the Ford Focus before doing a BMV search in the middle of the trial after a juror asked about it. He said the juror asked if it was the only 2016 black Ford Focus registered in 2017. Rozzi begins to describe witness testimony, saying that Brad Heath said he saw an unusual man that day. He said the Betsy Blair testimony didn't tell the whole story. Rozzi says, quote, I have to take a breath before I talk about here, when referring to Sarah Carbaugh. He says Carbaugh conflated muddy with bloody. He tells the jury they may discount a witness, calling it credible dubiosity. He says the jury that they can discredit Carbaugh. Rozzi says the prosecution did not tell them about David McCain, Shelby Hicks, or Cheyenne Mill because it, quote, doesn't fit their narrative. Rozzi tells the jury the prosecution didn't include Allen's timeline regarding how he got to the bridge. Allen nods his head in agreement in the courtroom. Rozzi suggests to the jury that they should use 2 pieces of evidence to exercise common sense. The 2 interviews from October 13th and 2022. Rozzi says that Brad Weber's gun could not be excluded as the one that cycled the cartridge found at the scene. Rozzi says Weber had sticks in his garage, and the state did not mention that. He brings up Weber's account changed from February 13th. Rozzi talks about phone calls on April 3rd, 2023, that the state didn't bring up at all. Rozzi says the state did not offer up information on the FBI leaving the investigation. He says the sticks laying on the bodies were not collected. Rozzi brings up the Westville videos of Allen. He says Allen was in solitary and without human interaction. He says the state only wants you to hear a few words. Rozzi says the magic bullet is the majority of the state's case. He says the state just wants the jury to believe Oberg and ignore the state not bringing up photos. Use your common sense, he says. Rozzi mentions Libby's phone being plugged into an accessory was not brought up by the state. He shows the jury a phone timeline. Quote, you should question their credibility, Rozzi says, referring to the prosecution. He says the state was desperate to make an arrest. Rozzi tells the jury that the Brad Weber van detail was only recently added this year. He says it took 7 years for the hair and DNA testing to occur. Rozzi says that Allen's Google searches have no proof that Allen actually made the searches. The searches are only registered to his email, he says. Rozzi says the Google search information was forensic examiner Chris Cecil offering the jury, quote, fast food. Rozzi tells the jury that the man who performed the autopsies on the girls, Dr. Roland Kaur, said in a deposition that there may have been more than one murder weapon, and now it says could be a box cutter. He says Kaur said this after the meeting with the prosecution 3 times. Rozzi tells the jury that they should consider that Carbaugh didn't see anything. He says the state only has a few key moments in their timeline. February 13th at 2:13 p.m., the Bridge Guy video. February 13th at 3:56 p.m., Carbaugh sees a man on 300 North. Rozzi calls Carbaugh's testimony worthless. He says Abby would have lived for 5 to 10 minutes and could have screamed, but nobody heard any screaming. Rozzi said the state ignored that there could have been more than one killer. He also says they ignored that someone could have accessed the bridge from the south side. He says the state suggests the crime was labor intensive and committed by a 5'5" man without a trace in a short period of time. Rozzi says, quote, "It is just implausible." Rozzi tells the jury Allen went to law enforcement after the murders in 2017 and was also cooperative in 2022. He says Allen still cooperated after he knew he was a suspect. Rozzi says, quote, "Even through the face of lies, Allen stood strong." He says Allen lived in the community and didn't have a reason to leave because he didn't do it. Rozzi brings up the forensic examination Oberg did of the cartridge found at the scene. He says Oberg's testing did not show sufficient agreement between the cartridge that was found and the cartridge that was tested. He says the photos from the cartridge testing should be the main thing the jury is stressed by because there is an agreement. Rozzi says Oberg told them, "You should just believe me." He says the state did not have the cartridge re-examined because Oberg's work was, quote, "so horrid." He tells the jury that Allen's situation in this case is unprecedented, referring to Allen being in solitary confinement. He says Allen was treated like a convicted murderer. Allen nods in agreement in the courtroom. Rozzi tells the jury that Allen was, quote, "immediately placed on suicide watch. Everyone would have a breakdown under those circumstances." He says Allen was in solitary confinement for 13 months. He asked, quote, "How much can one human endure?" Rozzi says it was insulting that the state did not want to see the jury to see the video of Allen in Westville. He says if Allen was not faking it, and even Dr. Walla and Dr. Martin said they weren't sure he was faking it. He says the Indiana Department of Corrections medical standard was to keep Allen alive. Rozzi tells the jury, quote, "You should be insulted." Rozzi says Allen was having false memories during some of the confessions. He says the state lied about Libby's phone. Rozzi says someone was using the phone between 5:45 p.m. and 10:32 p.m. on February 13th. He said someone plugged something into it during that time. He says there's no explanation because the phone is right. Rozzi tells the jury that there is no trace evidence that connects Allen to the crime scene. He said that Dr. Polly Westcott, a neuropsychologist, said that Dr. Walla's notes read more like a story, despite Allen being psychotic and not coherent. He says the state was desperate to make the sound in the bridge guy video the sound of a handgun racking. Rozzi tells the jury there is a question as to if the girls' bodies were at the scene during the evening on February 13th, 2017. He says the Smith & Wesson cartridge found in the memory box is a very common brand. Rozzi says Allen found God because he was in a cell alone with only a Bible, but that's not why he confessed. Rozzi tells the jury there are 5 components for the jury to keep in mind. 1, nobody identified Allen as bridge guy. 2, no digital data connects Allen to the crime. 3, no clothing connects Allen. 4, no DNA connects Allen. 5, no trace material connects Allen. Rozzi acknowledges the girls' families. He says this has been a long journey. Rozzi says, quote, "At the end of the day, the state's timeline has crumbled. The magic bullet is nothing more than a tragic bullet." Rozzi shows the jury a photo, a rack, a medieval torture device. He shows a photo of a thumb screw. He says these tools are not far from what Allen experienced in solitary. Rozzi says these tools are still used, they're just evolved. Rozzi shows 4 photos of Allen in prison. In the photos, he is covered in feces and being dragged while wearing a spit hood. News 8's Kyla Russell says while the photos are shown, Allen looks away. His wife, Kathy, is crying. Rozzi says, quote, rendering a verdict of guilt could be endorsing this behavior. Rozzi asks the jury to set Alan free. He is finished at 12 p.m. after speaking for an hour and 17 minutes. Sounds like pretty powerful closing statements, and now this case is in the jury's hands. What do you guys think is going to happen? Let me know. Let me know. I don't agree that the defense was stopped from presenting certain defenses. The defense should be able to prevent any defense they want. I agree. I think it's completely messed up. I couldn't convict him based on all that doubt. There's too much doubt. Welcome back, Ange. And that's still confusing, BZ. Did he or did he not know? Only details the killer would know. They say that's the white van. I don't know. It's just, none of it makes sense, really. None of it makes sense. Well, that was a good time, Buster. Let's go back to our court. Thank you for listening to that. Even if you're not following that case, it is a case that a lot of people have followed for 7 years. And I know that we were hoping for answers, right? Like, we thought that this trial would give us answers. We thought that it would tell a story of what actually happened, and it didn't. It left us with more questions than answered. We found out that the state hid things. They lost things. They, quote unquote, accidentally deleted things. I mean, none of it sounds just or right. And I don't know how you could ever sentence a man to prison for the rest of his life based on... The only thing that really bothers me is that I don't think I've ever heard of, like, someone confessing and a jury finding them not guilty. Have you guys? Yeah, it's more questions. We got the Kelsey's hair answer right, but they didn't even test that hair until the trial was going on and it was brought up. I wish it was televised. Yeah, me too. Amy, it's a crap investigation. And the question is, was that done on purpose or not? Exactly. I mean, being that it's her sister's hoodie, I can't go with that. Her sister didn't do it. If anything, this was a pedo ring. And there's shit being covered up, but why? In my opinion, that is. I don't know Bomber Trucker how often he went there, though. They never gave us any evidence that he was there. They never produced any GPS evidence about Alan. They said, oh, we couldn't find his phone, but then that woman testified, you don't need the phone. No cameras, no wonder. Oh, it's very sad. A dog in a shelter is treated respectfully, and they aren't treated like this. I agree. His treatment was awful. Right. She put her hands through the sleeves of the hoodie. Hired EMT says they wanted a scapegoat, and in my opinion, the local LE was involved in a cover-up. So what do you guys think of this? Here's a theory. What about the theory that Keegan Kline could have been selling preloaded phones with the apps already on them and pictures of the girls that he's talked to, and sold the person that phone and just handed over a phone with those accounts? What do you guys think of that theory? Absolutely. The last person to Snapchat Liberty German should have been put on the stand. Crimes. I have no idea how that even happened. It'll be really interesting to see what transpires with that prison after this is all said and done. I'm not sure. It's sick. Hearing about his treatment in that prison, it's sick. The whole thing is just, am I cutting in and out? Oh. Was I cutting out that whole time? Okay, is it better now? Let me know. Can you hear me now? I know I was muted. I muted myself. I'm back now. It's fine now? That's weird. Okay, we're good. Thank God. Other channels are having an issue as well. Well, that's odd. I say we start a new stream for the PM then. Okay. Testing, testing, 1, 2, 3. Testing, testing, 1, 2, 3. Premeditated said she can hear me loud and clear. I wonder if it's YouTube because it's cutting out on my phone as well. All right, I don't know if I'm cutting out or not right now, but I'm going to get a new stream ready. If people go out and come back, let me know if it's okay. I think just starting a new one just in case. Because I don't want it to break in and out on the actual hearing. That would suck. So let me get this ready. We won't miss a beat, guys. We won't miss a beat. I don't even know if y'all can hear me or not. But I'll have a new link for you guys. Don't go anywhere. Don't go anywhere. I don't know why I'm cutting out. It's so weird. It's cutting out for me. Defo cutting out for me. This is ridiculous. All right, hold on for that link. I will have a new link. It's so weird that it's fine for some people and not for others. It's definitely effed up on my phone, so we're just going to go ahead and start a new stream. All right, here's the new link. You can hear me. We'll go to the new one because I'm going to restart just in case it's me. And I'll see you guys in just a couple minutes.